Thank you all for joining us on this Sunday, and good afternoon to everyone here from Bangkok. It is a pleasure to welcome you to this webinar organized by the Center for International Dispute Resolution. We have a very stimulating topic for today's discussion on judicial intervention in international arbitration process, essentially dealing with the external relationship between national courts and arbitration, where courts exercise its supervisory and supportive powers. Judicial intervention is, of course, necessary where it is to ensure integrity of the arbitration process, but at the same time, judicial interference is fundamentally at odds with the principle of party autonomy, eroding confidence in the system itself. Our speakers today will shed light on this very topical issue, dealing with the scope of judicial intervention in international arbitration, as well as to reflect on the practice of the Thai courts in this regard. We have a wonderful panel of speakers. We have Dr. Nisit Intamano, who will speak first. Dr. Nisit is a professor of law at Sri Patum University. He is also an associate judge at the Central Intellectual Property and International Trade Court, which is also one of the competent courts under the Thai arbitration law. And we also have Leela Ketuntot, who is legal counsel at the Thailand Arbitration Center. Her work focuses around case administration as well as looking at the policy side of alternative dispute resolution. On the housekeeping side, please feel free to submit your questions while the panel presentations are going on. We will place those questions to the speakers at the end of their presentations. And if you would like to specify which speaker you would like to have respond to your question, please do indicate that as well. Please note that this webinar is being recorded, so please take note of that. Without further ado, I would like to request Dr. Nisit, who will provide a broad overview of the topic itself, which is judicial intervention in international arbitration, to please go ahead with your presentation.
Can you hear me? I might have a little bit technical problem, but hello. I'm sorry, I don't know what really happened. But...
Dr. Nisit, we could hear you just then if you want to try again.
All right. I think it sounds better right now, right?
Yes, it does.
Okay, I'm sorry for technical problem. I think this might have some particular issue. And thank you very much for inviting me here. It's an honor to be here. I work at law school basically, and at the same time, I'm practicing as a mediator for several years. Now I serve in the court as associate judge and also helping passing quite a few regulations for providing legal action for Thailand. Thank you very much. Okay, come to the point. First thing, I would like to introduce you to the legal system of Thailand about arbitration. In Thailand, literally, it say Anuyato Tulakan. It's come from two words. That's very interesting. The first word, Anuyato, is mean promise or Anuyat. Tulakan is mean judge in Thai. So technically, the one who comes with the idea saying this is mean the judge who specially get permission from the party itself. And that is the most important thing about this word. So Thai people get, I think we get used to this word for a very long time. The first time that I searched and I found this word in the Civil and Commercial Procedure Code, it's been a long time, but it's very interesting because the term they use is mean the arbitration in the courtroom. It's kind of interesting because that's the legal system we have it for, I think, almost 70 or 80 years. I studied that, but no one ever seen that happen. So the law that we talk about right now, we have the new act. Is called the Arbitration Act, and most of it, I would say above 90%, it's come from the Armstrong model law that we talk about today. And you have time to practice in Thailand, I would like to tell you that the Thai law right now is separating from the Code of Civil Procedure. We have the regulation in the institution. At the same time, we have the act itself. It's been practicing for quite a few times. And today, according to my research, I found out that in many countries, especially for India and in the Middle East, the judicial intervention is really hot debate and a lot of problem. I look at Thailand, we really that have a lot of problem during the process, but we have more problem for enforcement of international abroad. So right now, I could, according to my research, I found the judicial intervention in Thailand can take place in 3 steps: prior judicial institution, prior arbitral proceeding. Second, during arbitration proceeding, sometimes we see court to some extent get involved. And the last thing is after arbitration tribunal come up with award and enforcement. So this is quite similar to many countries, right? Before proceeding, during proceeding, and after proceeding. And according to the law, there's only 5 provisions that indicate the judicial power that might get involved in arbitral proceeding. I shall start with the first one, the law in number 9. It say the judicial court that might have the competent court under the act. Surprisingly, there's 4 court according to the law. Section 9 said the competent court under this act shall be the Central Intellectual Property and International Trade Court for international trade or international dispute resolution. And second, the court that the arbitral proceeding conducted. If that happened in Thailand, that would be the competence. And the last one is the court in which either party is domiciled or a court have jurisdiction over the dispute that submit to the arbitration, as the case may be. So if you talk about judicial intervention in Thailand, this must be under these 4: international IP or international trade court, the court that arbitral proceeding conducted, the party domicile, or the dispute had been submitted to the arbitration. That's maybe that is 4 court, the common court. Then Section 14 of the Act. In case where any party to the arbitration agreement commences any legal proceeding in court against the party in respect to any dispute in which the subject that the arbitration agreement, the party against whom the legal proceeding are commenced may file with the competent court no later than the date of filing statement of defense or within the period of filing statement of defense as a motion to request the court to issue an order striking the case, so that the party may proceed with arbitral proceeding. So this is the first provision that really related to the judicial intervening power. If the party bring the issue that something wrong with the proceeding or even the proceeding arbitration court, effective or not.
Then we come with the first thing with this court. All right. And then section 16, with I think this is more technical problem in Thailand, and we can spend most of time. And Kunina, I think you might prepare for this issue. Number 6,
Section 16, the party to arbitration agreement may file a motion, request a competent court to issue an order imposing provincial measures his or her interest before or during arbitral proceeding.
This is really important because sometimes in the academic review, they say provisional measures in the court, you need to file the case to the court first. But for arbitration, you can see the word saying even before the proceeding might take place. All right, and then the court would have been able to issue such order. The court may proceed the request, and then that would do under the civil and procedural code shall apply. So this is the second judicial power that involved with arbitral proceeding.
Sorry to interrupt, Dr. Nishid. We can't hear you.
Can you hear me?
Your sound has been off.
I think there might be a problem of echoing my voice on the earphone. Can you just take the first one, we say Dr. Nisit Intamano out of the screen? This might help.
We made it two mirror screens for Dr. Nisit.
Right.
Can we eliminate one with
Yeah. Can you eliminate Dr. Nisit Intamano, that one?
Yes, now okay. Now.
Oh.
Okay. All right. I think it sounds good now.
Dr. Nisit, your voice is audible now, and it seems to have got rid of the echo that was earlier. So if you want to continue, thank you.
Yeah, thank you. So you can either probably then just take the big one on the screen right now. I'll come back to next section that's really related to the power of judicial intervention. Section 18. Unless and otherwise agreed by the party, the proceeding for appointment of arbitral in tribunal. And Section 18 come up with the two separate idea of the sole arbitrator and the form of more than one arbitrator. And in any case, if the appointment of arbitrator proceeding under paragraph 1 has a problem to some extent of the party cannot agree with that, or either both party or one party, then one party can file motion to the court, which means Section 9 competent court to appoint arbitrator as deemed appropriate in the case. So this is the next thing. If they have any problem of choosing arbitrator, one party can ask the court for appointment of arbitration. And next, it's quite important, Section 20. A party who intend to challenge an arbitrator, they can do it, but they have to do it within 15 days after becoming aware of appointment of arbitrator, or the fact stipulate that in the previous section, they can file a statement that the ground of challenge with the arbitral tribunal or any arbitrator. And unless the challenge arbitrator withdraw from his office or the other party agree to challenge, then the challenge party can bring the case to the competent court again. and the court have to decide within 30 days after receiving notice of decision rejecting the challenge or the date of knowing appointment of arbitrator. So this is quite important for the next step after the appointing who is the arbitrator, and then you can challenge under section 20, then you can go to the court on the section 9 again. And section 21 talking about if any disagreements for the course of the arbitrators might not perform his duty or refuse to accept his appointment, then either party may, by motion, request the competent court to decide on the termination of the arbitrator's status. So section 21, again, provide judicial power for determine the determination of arbitrators. Still, they have to use this court as the power of working on this. All right, this is the big picture of the provision itself, talking about how court can intervene with the proceeding during the process. According to my research, I found a few cases that's quite interesting that is related to the case that I mentioned right now. The first case is about the is a contract for wait a minute. Okay, it's a sale contract for selling the rubber bands with stipulated must be a certain type of the band. The technique is called RSS3, and the seller look at the product that they get and they say it's not correct. The product is RSS1, which is not the same with the sale contract, and it's also saying below the package. So the customer reject to receive the products, and then the party bring the case to the court. It's quite interesting. In this case, the Supreme Court, the case number is 11949/2556. The court ruled this case quite interesting. They say the dispute in this case is the problem about delivery the product different from the contract, but it's not relating to the quality of the product. So the court decide it is not in the scope of the arbitral proceeding that provide in the contract. So the buyer is not get any involved in this case, so they can't bring the case to the arbitrator. They have to get the case to the court because the court interplay is quite different. This is the first case, and the second case is in the same year. In this case, according to the law that I just telling you, the law stipulated that if you want to challenge the dispute that come to the arbitration, you have to do it. In Thailand, it's quite very quick. You have to do it no longer than the date that you submit the statement of defense, or within a certain time you can do so. In this case, the defendant does not come up with the statement that say, we not agree with it and we want to get the motion for the court to dismiss the case. He answered, but he has some defense in the answer of the claim, saying that the defendant cannot come to the court before the arbitral proceeding. So it's fighting for the first court, second court, whether what the judge should order this case correctly. Because according to the law, literally, it says you have to submit motion to dismiss. But this case, he not submit the motion to dismiss. He answer with the claim. So the Supreme Court come up with a decision that even the defendant is not sent the motion to dismiss, but he already come up with the statement in the answer that he not agree with the idea. So the Supreme Court finally, after several years, say the first court has to dismiss the case and start working on arbitration process according to the contract. So not many cases involve the challenge of the court. And finally, I would say more happened in Thailand is the last thing. It's mean after the judicial intervention come up with the idea for enforcement of arbitral award. That is more technically problem in Thailand, especially for the word against public policy. And that may be another discussion. We can talk about that for the first round. So I would like to end the first round with this. Thank you.
Thank you, Dr. Nisit, for that broad overview and very insightful analysis of the cases you raised and how the court has addressed these issues relating to the arbitration agreement in particular. We now move on to more particular aspects of the court's intervention relating to the grant of interim measures and also looking at the assistance of the courts in terms of default appointments of arbitrators. I now request for Leela to please deliver her presentation.
Okay. Good afternoon, everyone. Can you hear me properly? Okay.
Yes, we can hear you, Leela. Please continue.
Okay. Thank you so much, and thank you for inviting me to be one of the speakers in this panel. Please allow me to introduce myself once again. I'm Leela Gekuntot, and I'm working as a legal counsel at THSC. Today, I has been assigned to make a presentation mainly focused on the interim measures, the appointment of arbitrators, challenge of arbitrators, and the last part is going to be the statistics of the judgment and the orders of the Supreme Court, Administrative Court, and also Supreme Administrative Court regarding the enforcement and the setting aside of the award last year. So let me start with the interim measures first. Actually, I would say that interim measures are necessary, and it is a very significant mechanism to protect the interest of the claimant in the arbitral proceedings. And it's very common in the arbitral proceedings in any other contracting parties in New York Convention, and also Thai Arbitration Act 2002, which is still in force and governs the domestic and international arbitration, also confirms this principle in the Act too. And the authority of the competent court is mentioned and stipulated in Section 16 of this Act, and it's clearly said that if the parties request to the court in order to order the interim measures, they can go straight to the court, and even before or during the arbitral proceedings, and the court might consider the request if it is deemed appropriate to issue the interim measures or not. So and I might say that in this section, it does not empower the arbitral tribunal to grant the interim measures. So it's clearly said that you have to go to the court, the competent court anyway. So let me clarify in details. Actually, as I said before, this provision has not empower the arbitral tribunal to grant the interim measures, but it's clearly stated that the party need to file a motion request to the court, and the court will like consider if it's appropriate. The court will issue an order relating to the interim measures, and at this moment the Thai court will apply the provisions relating to the interim measures in the Code of Civil Procedure, which is Article 263 to 273 of CPC, and apply that provisions to the arbitral proceeding like mutatis mutandis. And the Supreme Court of Thailand also confirmed this principle too by the judgment number 3883/2559. The Supreme Court confirmed that when the competent court need to issue the interim measures, they will apply the provisions in the CPC to arbitral proceedings. So in details, the interim measures under CPC are very limited. There are only 4 conditions to 4 types of orders that can be issued by the court. It includes the orders for the deposit of money as security, seizure of property or funds, and temporary injunctions to restrain a party from continuing or repeating any act, transferring or disposing of property, and orders directing public officials to register, modify, or cancel registrations relating to the property. And emergency applications are also permitted where there is a proven emergency requirement for provisional relief. However, let's come to the point that they are still having some discussion on this matter, whether the arbitral tribunal has an authority to issue the interim measures or not, because you will see in the provision and section 16 that it does not prohibit the arbitral tribunal to issue the interim measures. And it does not clearly state that this is the exclusive power of the competent of the court. So you will see that some arbitration institutions in Thailand enable the authority, enable that the arbitral tribunal is able to issue the interim measure if he deems appropriate. But the point is, to be honest, is that there's no formal law in Thailand to approve that the tribunal orders that has been issued by the arbitral tribunal regarding the interim measures will be approved by the Thai court. So due to the lack of enforceability, it will be much more easier for the parties to go straight to the court in order to send a request to the court and get the interim orders. So that's the problem in Thailand. And you will see that Section 16 of Thai Arbitration Act 2002, it's contrary to UNCITRAL model law on international commercial arbitration. In UNCITRAL model law, it confirms that the interim measure issued by an arbitral tribunal shall be recognized as binding, and unless otherwise provided by the arbitral tribunal, enforced upon application to the competent court, irrespective of the country in which it was issued. So this Section 16 of Thai Arbitration Act 2002 is contrary to UNCITRAL model law. And I'm doing a research. I found that the mechanism can be also seen in the arbitration law of other countries too. For example, like India, under Section 17 of the Arbitration and Conciliation Act 1996, and in UK under Section 38 of the Arbitration Act, and also in Singapore under Section 12 of International Arbitration Act. These are the examples of the act that confirms the authority of the arbitral tribunal to issue the interim measures, which might be contrary to Thai Arbitration Act, and we will have to follow on this matter. And can we come to the second part? I will explain about the challenge of arbitrators in Thailand. So as you know that actually the arbitrators of the case has to perform their duties like impartial and also independence during the whole arbitral proceedings. But the lack of one or both of these characteristics might be raised as the ground to challenge that arbitrators. Whether it depends on whether it is an ad hoc arbitration or it is an institutional arbitration. So in Thailand, for ad hoc arbitration, we will refer to the Arbitration Act 2002. In Section 19, it basically provides us 3 grounds of challenging of arbitrators, which are lacking of impartiality, lacking of independence, and also lacking of the qualification that has been agreed by the parties that the arbitrators should have. So Thai court will rely on these 3 grounds to make a decision if the arbitrators need to be removed from the case or not. But for institutional arbitration, I can tell that we need to take a close look at the arbitration rules of each institute. The ground could be varied from institution to institution. So for example, like THSC arbitration rules, we provide the grounds of challenging of arbitrators in Article 28. 28. We provide 4 grounds of challenging of arbitrators, and 3 of them are similar to the Arbitration Act, which I explained before. But one more additional is included, the circumstance that make the proceedings lacking fairness. This additional ground regards illegality during the arbitration, which could affect the due process and the fundamental rights of the parties to being able to present their cases. So to be honest, actually there are no definition of a word impartiality and independence. What does it mean? What is the scope of these words? So it depends on the discretion of the court, and I have to say that it case by case basis. So today I prepare some examples of the grounds of challenge of an arbitrators by the Supreme Court judgment. So we will go to the first one. The first one is the judgment of the Supreme Court. Like in that case, a former shareholder of a company was appointed to be the arbitrator in dispute involving that company and another one, and the Supreme Court found the duty that that arbitrator should have the duty to disclose the past facts that could affect his impartiality and independence. And another example of relevant facts is that have to be disclosed is found in judgment number 3543/2561. It's the judgment of the Supreme Court too. So in that case, the presiding arbitrators failed to disclose the fact that he used to act as a counsel in a related court dispute based on the same facts. And the Supreme Court decided that expressing a specific opinion in a court dispute on the same facts might lead to the lack of impartiality and independence. So in that case, the Supreme Court set aside the award due to the contrast to Section 40 of the Arbitration Act 2002. So here's the examples of the judgment of the Supreme Court regarding the challenge or maybe the ground of challenging the arbitrators. It has to be mentioned once again that all these grounds have not specified in Thai law. So it falls under the discretion of the Thai court. And it's subject to the interpretation of each judge in each case. Because as for your information, Thailand is like one of a civil law country, and the judge decision of each case of one case is not binding the others. So it's case by case basis, and the list of inconsistency of the decision is very high. So we need to study more about the judgment of the Supreme Court. And when it comes to the the process of challenging the arbitrators in Thai ad hoc arbitration. It's stipulates in Section 20 of Thai Arbitration Act, a party shall challenge the arbitrator within 15 days after becoming aware of the circumstances that give rise to doubts as to arbitrators' impartiality and independence. And the arbitral tribunal will decide on the challenge if the challenge arbitrator does not withdraw from the case or the other parties does not agree to the challenge. And if a challenge is not successful, or in the case that they appoint only sole arbitrator, the competent court will be the responsible authority for making a decision on the challenge of arbitrators. So that's the overview of the interim measures and the challenge of arbitrators. Before ending my presentation, I found out that there are some statistics of Thai court judgment and on order regarding the enforcement and setting aside of the arbitral award that I think it might be useful for you. I'm not sure if you can open the presentation that I prepared. Can you open the PowerPoint? Oh, okay, then.
I think we give it a moment to see whether they can pull it up. If not, then we just take it as though it's not available at this time.
Okay, I think that might have some technical problems. Then I can explain it briefly. So, for your information, these statistics are the gathering of the decision and orders from Supreme Court, Administrative Court, and Supreme Administrative Court during the period of January to December last year, 2019, as the decision of the Court of First Instance and the Appeal Court are not publicly disclosed in Thailand. So here's the statistics. During January to December 2019, there were 22 requests for setting aside of the arbitral awards. Out of this total requests, 6 of them, the courts ordered to dismiss the requests and enforce the awards. And 11 cases, the court ordered to dismiss the request of setting aside. And just 4 awards were setting aside. And in one case, the party were allowed to withdraw the request for setting aside of the award. And you will see that, can I calculate the percentage? Wait a moment, please. The PowerPoint has not shown up. So it can be said that only so only 8% that the court refused to enforce. Okay, and you will see that only 18% that the court set aside the award. So I think this is how can we say that during the same period of time, there were 12 requests for the enforcement of the award, and Thai court enforced 9 of these requests, while 1 was rejected and 2 others the court dismissed the request. And the percentage, you will see that in overall statistic, we will see that the percentage of enforcement of the awards is getting higher. And on the other hand, the percentage of setting aside of the awards is lesser when it compares to the previous years. So I think this is a good sign that the Thai judge tends to pay respect to the discretion of the arbitral tribunal and intervene less. So I think I can finish my presentation now. I think it's cover all that I prepared.
Thank you, Leela, for that very comprehensive overview of both interim measures and the court's practice on considering challenges to arbitrators' independence and impartiality and the lack of qualifications. And sorry to everyone for the number of technical issues and for failing to bring up the presentation in time. We will be taking questions if anyone has any questions for the speakers. Please do submit them. I don't see any questions at this time. Okay, I see one question which I'll read out, which is it's a comment and a question, which is in many countries, court procedure is too lengthy and tedious. Considering the facts, would you think interim measures should be exclusively dealt with by the arbitral tribunal? If only the tribunal is vested with this power, what problems may there be? So either Dr. Nisid or Leela can address this question.
Well, Skin comes to me first, then Kulina can elaborate more topic. It's really big issue, and I think right now in Thailand it's quite clear that either in many institution rules, right? I think TSAC or TI in Thailand is stipulated the power of arbitral tribunal can order such provisional order, but technically, according to my research, most of the judges in Thailand not really agree with this part, and I don't know practically any arbitral institution ever use this power according to the rule itself, because most of the time, according to my research, I found out that those interim measure it must come from section 16. And according to what I'm found, I would give you some examples so you can see the idea in Thailand, what kind of interim measure that you have to get in order, because quite important. One case, the one party would like to transfer the property, the dispute property, and also some other corporation property out of the court. Sometimes they also want to transfer and sell because they know at the end they might lose the case. And that's the reason they have to ask the court to put in order, not to transfer and not to sell. For such power, that's for sure, arbitral provision. Tribunal cannot doing it. Or sometimes in order to not doing the same problem that's bring to the case, that would be very interesting, because again, it's really difficult for the third party who is not cloaked with the power of the court can order someone to do or not to do something. And even sometime, according to the law, you might ask in order for force someone to not go or give some document to the party. And then again, you can't just use private power to force someone. At the same time, we'd like to add a little bit of this issue, then you can see more clear. Section 33, I think, let me check. Yes, that's correct. The court has an opinion for, wait a minute. Okay, 33. That's the one. Okay. This is about the provision itself. In the case that you want to ask someone, you want to get subpoena for document a person, then according to Thai law, section 33 say a party or arbitrator itself can send a motion to the competent court for the subpoena and order for document. That's happened a lot. And then the court have to consider such motion before he can order yes or no. That's that one thing that's quite related to what we're talking right now, and it's quite important because according to a lot of cases number, this prevention measure or order from the court during the process of arbitral proceeding, once in a while in Thailand you have to get the motion to the court. And according to what I know from my legal experience itself, we do is pretty fast actually, because we know the rule and regulation and the court. I think the last few years this number of set aside going down, and also we cooperate quite well with arbitration institution. That's my comment.
Leela, do you want to add to what Dr. Nisit has said?
Okay. In my opinion, I personally think that Thai Arbitration Act need to be revised. Like it need to confirm that the arbitral tribunal has an authority to like issue the interim measures, because I personally think that the arbitral tribunal of the case is very close to the case, and they know like every little things of the case. So it will reduce the time to issue the interim measures, because when you go to the competent court, the court need to have a sufficient information in order to issue the interim measures. So and to for your information, like the order of the court of first instance can be appealed, and it can be revoke or change under Section 45 of the Arbitration Act. So this might take time, and it's not abide by the intention of the interim measures, because the interim measures is necessary for protecting the what do you call the interests of the parties, right? So it shouldn't take that much time. So this is my opinion. I think it should be revised, and it should clearly stipulated in Thai Arbitration Act that the order of the arbitral tribunal is like equal to the order of the court, and that's my opinion.
Thank you, and I think it's an interesting question. Obviously, I mean, just perhaps my very quick view is obviously the court itself has powers to enforce its orders that it has made, and just compelling third parties, or on the other hand, it's dealing with pre-constitution issues of urgency. I mean, in those situations, obviously, parties may seek the court's intervention for provisional measures. But yes, I mean, this is a question which there is silence under the Thai law itself, whether the arbitral tribunal can issue provisional measures, and to what extent this is the exclusive competence of the court. I'm not sure if any of our speakers are aware of any cases where the arbitral tribunal seated in Thailand has issued provisional measures which has been challenged before the Thai courts.
According to my knowledge, never heard of that. It might be, but I've never heard of that.
Okay. Yes, because just very recently, as Leela was saying, there were arbitral rules with an amendment enabling for an arbitral tribunal to issue provisional measures, but we have to see how that plays out before the courts in due course. A very good question. If there are any other questions, please do send them in. I don't see any other questions in the comment box at the present time. I just want to go back maybe to one of the issues touched on in your respective presentation. Maybe Dr. Nisit can also provide his opinion on this. Leela, you said the courts don't have a fixed standard on or fixed tests on how they determine independence and impartiality against the challenge of an arbitrator. How much difficulty does that create in practice? And also whether the arbitration center, what sort of test do you then consider when the respective committees are looking at this issue?
Thank you for your question. I think as there's no like definition and the scope of the word impartiality and like independence, so I found that it's difficult to determine the scope of these words. So as I said, it falls under the discretion of the court and it's case by case. So we just need to follow up the judgment of the Supreme Court to provide us the scope of that definition. So from my point of view at THSC, we have no case that challenge no case that we challenge the arbitrators. I think that's one case, but that challenge arbitrator withdraw himself from the case. So there's no such case that can share here. So that's my opinion. I think I found out that it's difficult to provide the definition and the scope of the impartiality and independence. I have never seen the definition anywhere else. So that's it. Need to follow the judgment of the court.
Perhaps maybe section 23 have something to do with this. An arbitrator should not be liable. It's about immunity, right? And I think that's also come from the model law. Any civil liability for the act performed in the course of his duty as arbitrator, unless it is performed willfully or with gross negligence, causing damage to either party. So that is immunity from civil liability. But at the same time, the paragraph 2 and 3 come up with the criminal penalty for the arbitrator. Any arbitrator wrongfully demanding, accepting, or agree to accept an asset or any benefit for doing something or omitting to do any act shall be subject to imprisonment for not more than 10 years. For not more than 10 years, or a fine not exceeding 100,000 baht or both. So paragraph 2, this is a criminal charge which is quite very strong for arbitrator. And paragraph 3, whoever giving, offering, or agree to give any asset or benefit to the arbitrator to induce him or do or admit anything or even delay the act shall be subjected to imprisonment for not more than 10 years. That's same. And a fine not exceeding 100,000 baht or both. So that's really strong immunity, and at the same time, also the criminal charge for those arbitrators and those persons who offer bribery. I would like to add a little bit more. Actually, section 24, dealing the time of arbitral proceeding, once in a while we have a case that come to the court decision for the jurisdiction of arbitral tribunal. If any cases there's the dispute of the scope of authority or power under jurisdiction of arbitral, then the party might submit the preliminary question to the court for the competent court again and file motion to dismiss, and the court will decide within 30 days to receive whether the proceeding that takes place right now is under the arbitral contract or not. So also section before that one thing to do with intervention from the court.
Thank you for your respective responses. Maybe I'll raise a question with Dr. Nisit. You mentioned about one of the challenges that made its way up to the Supreme Court I think it was case 11914, if I'm not mistaken. Please correct me if I'm wrong. Dealing with the scope of the arbitration agreement. Do you think a situation like this is better left to the arbitral tribunal to determine its jurisdiction? Or, in your opinion, in this case, it was a valid challenge that was upheld by the court?
I think this case is quite interesting, and once in a while, I have to admit, the Supreme Court judgment related to arbitration is really swing vote once in a while. Sometimes scale from this way, what is the meaning of public policy? What is a good reason for set aside? I think 10 years ago, we have a high number of the court setting aside a lot of international award enforcement, but right now it's quite different. At the same time, with the scope of power for arbitrations itself, I think this is really debatable for me. That's why I chose this case to talk about something, because if you look at it itself, the problem arising from the contract, but at the same time, the judge look at the contract and determine like the certain part of idea for under certain scope of judicial review the power of arbitral proceeding according to the contract. I think it's really sensitive and really interesting. And if you look at the cases, one case is going this, one case is going that, like Leela just said. And one thing quite interesting, Thailand, even we are civil law country, we look at it code of law rather than the Supreme Court judgment, but we have to accept it. If you work in Thailand as a legal profession, you know, most of the time you work on something, they will ask you, oh, you think about this? So what is the case number that you relied on? So it's come back and forth. And at the same time, I think they strictly looking at the result of the judgment rather than the reason. And I think that's something to work with it. And that's why we, in the court, to change certain structure. Certain cases will go to special section for the Supreme Court section itself, not like several years ago that we go to the review by ordinary judges in Supreme Court. So I think the rule regulations getting better once in a while. And like Section 9 is talking for a long time, which means which court you can go. You can just bring the case to the IP court anytime they want. A certain time, people think like that, but actually it's no. It's have to look at the establishment of the IP Court Act, which must be only certain the case that they can bring to the court. So the first 10 years, I would say there's a lot of problem for interpolating the meaning of the act. Even, I would say more than 90%, we drafted from the model law, but at the same time, they add something somewhere. And sometimes there's problem of misinterpret of the word that they literally translate from the model law. And that's been working for a long time. Right now, a lot of things getting better, more clarified in a certain provision, but still, in some area, they still work on it.
Leela, do you have anything to add on that point in terms of dealing with the competence of arbitral tribunals when considering the scope of an arbitration agreement?
No, คุณนิสิต like explain every little things of this topic, so no more additional comments. But in order to share for the participants information, I could say that last year, when can we go back to the enforcement of the award? Because last year we already know the result of the conclusion. I can say the conclusion of the one of the mega project mega construction project. And I think it's very good sign that Thai court, Thai Supreme Administrative Court, like intervene the discretion of the arbitral tribunal like lesser than before. And in that judgment, it's clearly stated in the judgment that it's clearly said that the Supreme Administrative Court agreed that the decision regarding the termination of the concession agreement included in the arbitral award is not contrary to the public policy. And moreover, the decision regarding the breach of the contract, it's based on the facts of the case and falls under the discretion of the arbitral tribunal of that case. So for this reason, the court said that the content of the arbitral awards regards only the relationship between the parties, and it does not concern the public policy. So on this ground, it is possible to set aside of the award. I think this judgment is a very good sign that Thailand and Thai judges really pay respect to the arbitration proceedings and the arbitral tribunal, the discretion of the arbitral tribunal. This is to share for your information.
Thank you, Leela. Unfortunately, I think that case now has been, there are some issues that have been referred to the Constitutional Court to consider further. So we still have to wait and see the outcome and the end of that particular saga. Without any further questions, perhaps if there are no closing remarks from our speakers, is there anything else that our speakers want to add before we close out the session?
Yes. If you have time to come to Thailand and talking about the arbitration, what really happened, I have to tell you that it's been working for 2002. Actually, we have the act before that time. In Thailand, we have quite a few number of institutions, but a certain time at a certain point, it's not really that popular because there are many cases that some government lose their case for the arbitration. At a certain time, we have I think that would be like the recommendation, that's a good word, from the cabinet to not use arbitration for the certain government project. And just a few years ago, they just changed the policy, then allow the government organization to use arbitration as a way to resolve disputes for a number of cases. But still, it still has some obstacles that a lot of like TSAC, TI have to work on it. Right now, as far as I'm concerned, the standard contract for service or construction of government project, they're deleting the arbitral course. And sometimes they ask me, can I put it back? And I say, yeah, they're not recommended, but you can use it if you want to. So sometime you have a good number of the cases come to their arbitration proceeding. Sometime they not really want to challenge because even it's not like say no you can, but governments do not really highly recommend it. And like what we say, the case just happened, and a lot of people have the really bad negative sometime, like, oh, we lose again, but they're not looking at the real fact and why they lose the case. So this is really a good trip at the end about Thailand, and but I think in a good way. Now the court understanding more a lot about it. The government again encouraged a big project to put arbitration, of course, and probably after the international trade going up again with China, and everyone know right now, right? China's government almost, when I traveled to China a couple years ago, almost every province have own ADR center or arbitration institution. And when we work more with China, investment, foreign direct investment in Thailand, and that's what I can see it. The factor from outside will force the Thailand for government and government officer to change the attitude about arbitration, and I think it's gonna be getting better. That's my comment.
Thank you. Any final thoughts from you, Leela?
I just want to promote Thailand. If the foreigners really want to be appointed as a foreign arbitrators or maybe representative in the arbitration proceedings in Thailand. Last year we amended the Arbitration Act, and in that amendment we clearly said that the arbitration institution is able to issue the certification for the foreign arbitrators and also foreign representatives of the parties, if they wish to commence the arbitration proceeding in Thailand. Once they get the certificate from the institution, they can apply for work permit like by using only 3 hours, which is very shorter of time when compared to the normal procedure, and also like use lesser documents when compared to the normal procedure. And last year we also issued one smart visa. If you are the expertise in arbitral proceedings, you are able to apply for smart visa, and once you get the smart visa, you can work as an arbitrator, or maybe specialize in arbitration proceedings in Thailand and without obtaining any work permit. So I just wanna promote Thailand that we are improve our act and our legal measures to invite all of you to commence the arbitration proceeding in Thailand, and hope that one day we can be a hub of ADR in this country, in this area. So that's my comments.
I totally agree with you.
Well, thank you for your kind final words, and thank you all for joining us for this very insightful session, and obviously a big probably have to be a silent round of applause for our speakers today, Dr. Nisit and Leela, for sharing their perspectives on the practice of the Thai courts and Thai arbitration. And thank you to the organizers and sponsors of this event. And have a nice evening or a nice day ahead of you, wherever you may be. Thank you.
Thank you.
Thank you.
สวัสดีค่ะ
สวัสดีค่ะ
Thank you. See you later.